Bienvenue tout le monde. I call this meeting to order. Welcome to meeting number 78 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the order of reference of October 5, 2023, the committee is meeting to proceed to the clause-by-clause study of Bill S-12, an act to amend the Criminal Code, the Sex Offender Information Registration Act, and the International Transfer of Offenders Act. Today's meeting is taking place in a hybrid format pursuant to the House Order of June 23, 2022. Members are attending in person in the room and remotely using the Zoom application. Those attending the Zoom application have been tested and the interpreters are okay with their sound. So I need to make a few comments for the benefits of the witnesses and the members, and these are quite important. So some of them are standard, and I say them all the time, and others pertain to just clause by clause. So first, please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone to activate your mic and mute yourself when you are not speaking. A reminder, all comments to be addressed through the chair. For those in the room, if you wish to speak, please raise your hand and I will recognize you. Those on Zoom, the hand function. The clerk and I will manage the speaking order as best as we can, and we do appreciate your patience and understanding. Now, we have Justice Department officials with us today to provide answers on technical questions throughout our study. So welcome again, Mr. Matthew Taylor, General Counsel and Director, Criminal Law Policy Section, and Madame Joanna Wells, Acting Senior Counsel, Criminal Law Policy Section. Thank you so much for being here, and I really value you being here, and I'm sure the members will as well. Now, we're ready to start clause by clause consideration of S-12. So please listen to this because we have not done it in a while, and on the committee there's a number that I certainly haven't done it as a chair, so I'm going to go slow to ensure that I recognize everyone I need to, give everybody the opportunity, and provide you with the information that I have. So this is how the committee will proceed through clause by clause. As members already know, this is an examination of all the clauses in the order in which they appear in the bill. I will call each clause successively, and each clause is subject to debate and a vote. If there are amendments to the clause in question, I will recognize the member proposing it, who may explain it. The amendment will then be open for debate. When no further members wish to intervene, the amendment will be voted on. Amendments will be considered in the order in which they appear in the bill or in the package each member received from the clerk. So here, please note the following, and this is really important, that amendments must be submitted in writing to the clerk of the committee. The chair, that's me, will go slowly to allow all members to follow the proceedings properly. Amendments have all been given a number in the top right corner to indicate which party submitted it, and there's no need for a seconder to move an amendment. Once moved, you will need unanimous consent to withdraw it. During the debate on an amendment, members are permitted to move sub-amendments. These sub-amendments must be submitted in writing, so there's no verbal ones on the floor. They do not require the approval of the mover of the amendment. Only one sub-amendment may be considered at a time, and that sub-amendment cannot be amended. When a sub-amendment is moved to an amendment, it is voted on first. Then another sub-amendment may be moved, or the committee may consider the main amendment and vote on it. Once every clause has been voted on, the committee will vote on the title and the bill itself. Finally, the committee will have to order the chair to report the bill to the House. That report contains only the text of any adopted amendments as well as an indication of any deleted clauses. So before I start, I want to thank in advance members from the legislative clerk office here with me that will be providing support to myself on any issue that might arise on the procedure. So, ladies and gentlemen, here we go. I call Clause 1. Shall Clause 1 carry?
Yes.
Thank you. Carried. I call Clause 2. If you look at page 1 of the package, you will PV1 is deemed moved pursuant to the routine motion adopted by the committee on December 16, 2021. Moved. Shall PV1 carry? Mr. Moore.
Thank you, Madam Chair. Just want maybe if the officials that are here from the department could provide some clarity on what this Green Party amendment would do exactly.
Yes, please, Mr. Taylor.
Thank you. Thank you for the question. It appears to us that what it is proposing to do is in current section 46.41, the language specifies victims and witnesses currently in the state of the law. What the amendment proposes to do is to replace the reference to witness generally with witness under the age of 18. That appears to be done to mirror with subsequent subsections in 486.4. The implication of that from our perspective would be that it would have the effect of excluding the ability of a court to make a publication ban under 486.4 for adult witnesses. So the general starting point is that all witnesses and victims of sexual assault, so primarily sexual assaults, fall within the scope of this provision. There are mandatory rules for child victims and adult victims and child witnesses. So if you limit it to witnesses under the age of 18, as is proposed, adult witnesses would have to rely upon 486.5 of the Criminal Code.
Mr. Brock?
Thank you, Chair. To Mr. Taylor, I was somewhat confused by the language in this particular amendment because, to your point, the code already provides necessary direction to the court when you're dealing with witnesses and victims under the age of 18, and the order is actually mandatory. It's not discretionary. And how this is drafted, with the word may, it provides a discretionary exercise, which kind of defeats the original purpose by which the code was drafted. Would you agree?
Certainly the purpose of 486.4 was to provide certainty to victims and witnesses in the sexual offenses listed, that if an application for a publication ban was made, that it would be given. And you all know, as you've heard, that the reason for that was to encourage reporting of offenses that are historically underreported.
Mr. Garrison, please.
Thank you very much, Madam Chair. We have a large number of amendments before us today, and we are working toward a deadline for getting this approved in Parliament. I have a concern, because the Senate has already passed, that if we make extensive changes, we will endanger meeting that deadline. So I'm not going to say this many times today. I'm going to say it once. I'll be voting only for amendments that I think are essential. And we heard from some witnesses about some things that we definitely needed to do, but we have a large number of other amendments here, and I'm concerned that that will result in a delay when it comes to the House dealing with the Senate.
Thank you. Mr. Maloney?
Just quickly, I want to echo what Mr. Garrison just said, and based on the questions we've just heard, I think it's, first, I appreciate the spirit in which these amendments were tabled. I am empathetic and understand where they came from. I think we all are, I know we all are. And, but I think, just to echo what Mr. Garrison said, I think we should, I will be voting against this amendment and some of the others for the same reason. And I think in the interest of time, we should maybe move on.
Can I call for the amendment, please? Merci. Shall PV1 carry? No. Okay. What is
It's negative.
negative?
Negative. Defeat.
Thank you. Negatived. Mon Dieu. Okay. We have PV2. Shall PV2 carry? Okay. We'll go for a recorded vote, please. Is that where you come in?
Yes, on PV2.
Yes, please.
Okay. Mr. Moore?
Yes.
Mr. Brock?
Oui.
Mr. Caputo?
Yes.
Mr. Van Popta?
Yes.
Mr. Fortin?
Oui.
Mr. Garrison?
No.
Mr. Maloney?
No.
Madame Brière?
No.
Mike Callaway? No.
Callaway.
Thank you. No? Okay. Madame Dillon?
No.
Mr. Osfather?
No.
Only 6, PA 5. It's defeated.
Merci beaucoup. PV2 is defeated. Next, we have CPC-1, which is at page 3 of the package. Would the member please like to move that? I don't know which member it is, so you decide.
I'll move it.
Okay, moved by Mr. Moore. Shall CPC-1 carry? Recorded vote, please, Mr. Clerk.
This one, CPC 1. Okay. Mr. Moore?
Yes.
Mr. Brock?
Yes.
Mr. Caputo?
Yes.
Mr. Van Popta?
Yes.
Mr. Fortin?
Oui.
Mr. Garrison?
No.
Mr. Maloney?
No.
Madame Brière?
No.
Mr. Callaway?
No.
Madame Dillon?
No.
Mr. Osfather?
No.
Only 6, C5 defeated.
Okay, merci beaucoup. It's defeated. Next, we have CPC-2, page 4 of your package. Would the member like to, would whoever member would like to please move it?
I can move that, Madam Chair.
Thank you, Mr. Brock. Shall CPC-2 carry? Okay, thank you very much. It's defeated.
Well, we obviously were in favor of it, so.
Oh, I didn't hear anybody say yes, so you have to, on division? Is that, okay, thank you. Thank you very much. CPC-3. Would a member like to move that one, please? Mr. Van Popta, thank you so much. Should CPC-3 carry?
Non, Madame la Présidente, je voudrais.
Madam Chair, I'd like to intervene on CPC 3, please. Yes, go ahead. Thank you. I was looking at this amendment, and what it's proposing is a delaying exercise. The Criminal Code currently provides that such an order be made as soon as possible. S12 tells us I can't read my own handwriting, but as soon as possible. And now it says immediately in this amendment. So, Madam Chair, I understand that what they want is for this to be done as fast as possible, and of course I agree with that. But when you say immediately, that presents an interpretation problem. What does immediately mean? 5 minutes later, you have to do it? Logic says that the prosecutor will not interrupt a judge by saying, by the way, there's an order here. So I think the word immediately could be interpreted as being as soon as possible or on the first possible occasion. I don't think this is a useful amendment. I think it complicates our lives and would give rise to contradictory decisions where courts will interpret this in different ways. So the text of S12 as it stands seems reasonable to me. If ever we want to change it, we'd have to specify what immediately means. Maybe within 48 hours or something of that nature. But immediately is not applicable. You can't do it immediately when the judge says it. Even in the English version, it says immediately, immédiatement in French. I don't think that's appropriate. Thank you very much, Mr. Fortin. Okay, so now I would ask.
-3 shall carry. On division, thank you very much.
Non. Voilà. Je
Mais-
vote contre, moi.
I'm voting against. Okay, thank you.
It does not carry. PV3, page 6 of your package, is deemed moved. Madame May, would you, I see that but you weren't tested though.
I had trouble getting connected to you today. So if you want to test my microphone now.
Yes, Madam May, please go ahead.
Wait, I'm just trying to see why I don't, if I'm on screen or, and I'm testing en français. Je suis désolée parce que j'ai manqué l'opportunité.
I'm sorry because I missed the opportunity. My amendment has already been defeated earlier, but I'm here now. Is this working?
Should I proceed at this point, Madam Chair?
Yes, would you like to say a few words on PV-3?
Yes, I'd like to make it clear, Madam Chair, and I don't know, I'm getting feedback if there's anything to be done about that. But I'd like to make it clear that I'm only here before the Justice Committee because I am getting this feedback. All right, I'll proceed again. But it is unpleasant if someone can fix it at your end. I'm only here because your committee, all of you members here today, passed a motion in which I am required to show up with my amendments to committee rather than being able to exercise the rights I would ordinarily and otherwise have at report stage before the House as a whole. So I just like to put it on the record every time that I'm put through this process that it's not my choice and it's not my desire. And I now have, under the terms of your motion, the right to speak to my amendments.
Okay.
So this amendment, again.
So, Miss May, I need to let you know what I've been told. You're signed on 3 times. in three different names on the screen, and that could perhaps be why we're having difficulties. They are instructing me to tell you to just please X off all three of them.
Well, as long as I won't lose my rights to speak to this amendment, as I did lose my rights to earlier ones due to technical problems. So I'll leave and come back, Madam Chair, or hopefully I'll only, when I leave one, I'll come in on the other. Okay, I've left one.
Let's
We've left one of them, that's a good sign.
no, you're more.
So, Miss May, I'm going to suspend for 5 minutes. I think it's only fair, but beyond that, there's not much else I'd be able to
Here
do.
now, it's still a technical problem.
There's still two accounts.
I'm suspending for 5 minutes. again, it's exactly 5 minutes and we will proceed. So, Ms. May, you have the floor to speak on PV-3, please.
Yes, thank you, Madam Chair, and again, apologies for the technical difficulties. I am, of course, bringing forward amendments today based on testimony the committee has heard, and I know that my friend there from Esquimalt, Saanich Suk, has already spoken on the floor of the House as well. The extraordinary work of the group My Voice, My Choice. This amendment comes from their testimony and their evidence before this committee. And the purpose of, and PV, of course, just to explain for people who have, I don't know, Madam Chair, we haven't been in the same committee together before, but this was an old designation chosen by the House because, of course, Green Party would be G-3, and then it would look like a government amendment. So Parti Vert, PV3. The reason I'm putting forward this amendment is to meet the situations that have existed in real life, extraordinary as they are, where victims find themselves subject to publication bans without knowing. Of course, that's the purpose of S12 is in this section, is to fix that. So what the amendment I'm putting forward at this point would add in after section 486.4, that's after subsection 2, to make it clear the prosecutor may make an application for an order only after obtaining the written consent of the victim or witness who is the subject of the order and demonstrating the satisfaction that all reasonable attempts have been to communicate with the victim or witness have failed. So there mustn't be a time when a publication ban is applied when the victim has not been made aware of the fact that this is being brought in. I hope that's clear and a good summary. Thank you, Madam Chair.
Much. Mr. Caputo.
Thank you. My understanding is from experiences the publication ban occurs by operation of law. The question I think we have to grapple with as a committee is this. Do we want something within the amendments that say that there is a requirement to let victims know of their right to set aside the ban? I mean, that's the fundamental question here. And we've got a number of amendments here. I'm not sure, just gauging the people in the room here, whether that's palatable, because we would need a sub-amendment, or we just cut to the chase and say, nope, that's just not something we're open to. I know that might not be conventional, but that's my sense. Thank you.
Shall PV3 carry?
Yes.
No.
Do you want me to get a recorded vote? Yeah. Okay, please, Mr. Clerk.
Yes. Mr. Moore?
Yes.
Mr. Brock?
Yes.
Mr. Caputo?
Yes.
Mr. Van Poppel?
Yes.
Mr. Fortin?
No.
Mr. Garrison?
No.
Mr. Maloney?
No.
Madame Brière?
No.
Mr. Kellaway?
No.
Mr. Housefather?
No.
Madame Dillon?
No.
Nay 7, yea 4. Defeated.
Thank you. The PV3 is defeated. PV-4. Shall PV-4 carry?
Yes.
Would you like a recorded vote, or is it on division?
No.
No? Recorded vote, please.
Je voudrais discuter, Madame la Présidente.
I'd like to discuss it first, please, Madam Chair. Okay, look,
Committee passed, I do believe I do have a right to speak to PV4 to explain the reasons that it's being put forward before it's summarily defeated.
Monsieur Fortin,
Mr. Fortin.
up your hand, so I didn't know, and it's not necessary by the rules, so it's up to you, but do let us know if you do, but I'll let Monsieur
J'ai
Fortin.
pas de problème.
I don't have any problem letting Madam May speak first. It's your decision, Madam Chair. I'm ready, but if Ms. May wants to speak first, I have no objection. Thank you.
Would you like to say a few words on it before Monsieur Fortin speaks?
Yes, again, it's terrible. I'm very surprised that the last amendment was defeated because really I did think that the committee was aware, as I thought the minister was aware, that S12 will need amendments in order to meet the goals of ensuring that victims are not subjected to publication bans without their knowledge, and that therefore the amendment again here is attempting to achieve as others are before you, that the rights of the victims are reflected in their knowledge in advance and permission that publication bans apply to them. And I would certainly, I'm disappointed. I appreciate very much support from a number of colleagues around the room, but I don't understand why we wouldn't want to ensure that these amendments are all carried that go to the issues raised by My Voice, My Choice. Thank you.
Est à vous maintenant.
You now have the floor, Mr. Fortin. Thank you, Madam Chair. On the previous amendment, consent in writing by the victim is just about impossible to get. On PV4, the problem we have is one of wording. It says witnesses that want to be wish to be the subject of an order. Then the victims aren't. It's the identity of the victim that is the subject of an order. It's disclosing facts and the evidence presented at trial. It's not the victim herself or himself. The same is true in English. There are some places in the criminal code where it's correctly indicated, but here we have a problem with wording. The victim wishes to be subject of an order. Well, there's no other. Ask any victims. Do you want us to make an order about you personally? They all say no. So I think that we have to re-look at the wording and say something like their identity be subject to an order, or all the facts disclosed in the trial be the subject of an order. But it's not the victim, him or herself, that's the subject of an order. Thank you, Mr. Fortin.
Now ask the question, shall PV-4 carry?
Yes.
Would you like a vote on that?
Yes.
Recorded vote, please, Mr. Clerk.
Sure. On PV4, Mr. Moore,
Yes.
Mr. Brock,
Yes.
Mr. Caputo,
Yes.
Mr. Van Popta,
Yes.
Mr. Fortin,
Non.
Mr. Garrison,
No.
Mr. Maloney,
No.
Madame Brière,
No.
Mr. Kellaway.
No, Madame Jones.
Oh, sorry, I'm sorry. I didn't look. My fault, sorry. Madame Jones.
No.
Thank you. Mr. Ausfather,
No.
Madame Dillon.
No.
Nay 7, Ye 4. Defeated.
Thank you. The PV-4 is defeated. Next, I have G-1. Would the member please wish to move it? Mr. Maloney.
I move.
So moved. Shall G-1 carry?
Non, je voudrais parler.
No, I'd like to speak against G1, Madam Chair. Yes, go ahead. So look, I have a problem with G1. A lot of testimony during the committee said, is the prosecutor in a conflict of interest when he explains what the order means? Some say yes, some say no. My opinion is that the prosecutor, the Crown prosecutor, cannot simply tell the victim, just be advised that there is an order of non-publication, period, full stop. And the victim will say, what does that mean? Well, just, consult around you. My job is just to tell you that there's a publication ban. It seems too short to me. I don't think it's respectful of the rights of victims. And the Crown prosecutor must explain to the victims what that order means, or ensure that victims are adequately informed by designated someone to do so. But in my opinion, we can't not be concerned with victims and just say, by the way, there's an order. And what does that mean? We're not explaining this to you. Just go consult someone else. I think it's too short. S12 originally was desirable and more respectful, in my opinion, of the rights of victims and witnesses. Thank you, Madam Chair.
Thank you, Madam Chair. I tend to agree with Mr. Fortin. I think, what we've heard in our testimony around victims of crime and around this legislation is victims are feeling left out in the dark and crying out for more information. And I will note that My Voice, My Choice, who have lived experience, advocated for this provision to remain in the bill. So I will be opposing this amendment. I think it's important that as much information, relevant information as possible, be disclosed to the victims.
Yes, Mr. Brock?
I too am leaning towards opposing this, Madam Chair, unless I can be persuaded by the Liberals as to the justification behind the amendment. I also agree with Monsieur Fortin. Our job as legislators is to be entirely clear when we are amending or passing legislation. And the way that this is drafted is so vague. It is rife for litigation. It does not indicate in any respect, with any specifics, how a prosecutor is supposed to discharge that particular onus. And I will add, very, very briefly, that I disagree with our Attorney General and some of the other witnesses who opined that this is a dangerous area in terms of how prosecutors are conducting their business in terms of their relationship and discussions with victims. I consulted with my colleague, Mr. Caputo, and I can recall for the years that I was prosecuting where I was dealing with very sensitive matters and dealing with victims, you have to supply those victims with a myriad of informational points with respect to the process. And I view this as a process-driven avenue for a prosecutor to share that particular information. So I think it's incumbent that we strengthen the language, not weaken it, and not make it so vague that it's unenforceable. Thank you.
Thank you. Mr. Maloney?
Yeah, I appreciate what both Mr. Caputo and Mr. Brock have said, and I respect the fact that they're both experienced prosecutors, but we did hear evidence about this potential conflict that the prosecutor could be in, and I will defer to your experience, but I don't see the wording of this proposed provision as preventing someone in your prosecutorial shoes as being unable to provide that myriad of information. In fact, it's intended to be a safeguard from those who may not perhaps have the experience that you may have in that situation. So I think it addresses the issue that was raised by a number of witnesses that we've heard over the last 2 or 3 meetings. Thanks.
Mr. Housefather?
Thank you, Madam Chair. I would tend to agree with Mr. Maloney. I think that this is really putting the prosecutor in a very sensitive position where they're going beyond providing information and they're essentially providing legal advice. And I would see a real issue if there was a breach of the protective order and the same prosecutor who had given advice was then supposed to prosecute the person to whom they'd given advice. And the person would argue that, that the prosecutor told them X and X and they were relying on what the prosecutor themselves told them, creating a real conflict of interest situation. So I would tend to lean on supporting this government amendment because I think it really creates an issue of confusion and potential conflict of interest. Thank you, Madam Chair.
Mr. Moore?
Thank you, Madam Chair. Yeah, having heard the rationale for the amendment, I'm more convinced than ever that we need to either the government needs to withdraw it or we need to oppose it. What we heard from witnesses is they're crying out for information. The prosecutor, and we have former prosecutors as resources here on our committee. The prosecutor is in a position to provide that information. We're talking about information related to the publication ban and the effects and the circumstances that someone may disclose information. This is what we heard at committee was people are relying on the prosecutor for these kind of information. When we heard that, well, some prosecutors could do this, and some prosecutors who are trained to do it could provide that information. Well, that's the exact point, is what we've heard is there's an uneven application. Some people are made more aware than others. Sometimes there's a prosecutor that would provide this information. Sometimes there's one that wouldn't. This ensures that Parliament is making its viewpoint known that this information should be provided to victims. So having heard the rationale for the amendment, I'm more convinced than ever that the amendment should be defeated. I would hope that the government would actually withdraw the amendment.
So just to make it clear so people know that I am noticing everybody that's putting their hand up, I've got Mr. Caputo, then I've got Monsieur Fortin, then I've got Mr. Brock, so you can start lining up. So, Mr. Caputo, please.
Thank you, Madam Chair. I think we have to remember what legal advice is. Legal advice is advising somebody about potential courses of action, the pros and cons of those courses of action, and advising as to what the person may wish to do. What this provision does, in my view, it actually says this is the information you must provide. It doesn't encourage or discourage a course of action. It doesn't say you should apply to set aside the publication ban. You should not apply to set aside the publication ban, or these are the things you should consider. That, to me, would be legal advice. For instance, I'm not sure, I'm trying to recall now, but I recall we used to have to send out letters under the Victim of Crimes Act, which would say this is a victim impact statement. And it wouldn't be uncommon for somebody to say, this is what can go into a victim impact statement. For instance, a victim impact statement cannot have information as to the proposed punishment, what the victim believes should be a punishment. Okay? That is objective. You can't do that. This is what a form of victim impact statement can take. Whether you should submit one, how you should express yourself, that's getting into advice. I think that this is the exact same thing. I could see it taking the form of a letter saying, this is what a publication ban is. These are your rights as a victim under the publication ban. This is what you can do. This is what you can't do. Do it as you wish. Get legal advice if you wish. Thank you.
Monsieur Fortin?
I won't waste any time here. Mr. Caputo said exactly what I was going to say.
Mr. Brock, followed by Mr. Maloney.
Thank you, Madam Chair. And I just want everyone at this committee to remark not only on the evidence that we've heard from victims and victim groups, but also some of the not the more experienced, but the members of this particular committee who have been around for a couple of years. We've heard from a number of victims over the course of my tenure as a new parliamentarian. And the message was extremely consistent by the victims that they feel that the Crown attorneys and the criminal justice system is completely unresponsive to their needs. So they want information. They want to feel part of the litigation. They want to feel part of the team. So the reason I'm asking the Liberal bench to consider amending this, to strengthen it, or to simply delete it is for that very reason. The victims want to have information shared by the Crown. They don't want a Crown simply to say, oh, the order's been made, but I can't say anything because I'm going to put myself in a conflict of interest. Crowns have an obligation to the community. They are public servants. They are ministers of justice, but they cannot and will not or should not exclude witnesses in discussing pertinent and really relevant information, which this currently is. Thank you.
Mr. Maloney?
Just brief, look, I don't disagree with what Mr. Caputo and Mr. Brock have said. I interpret the language used in the section prior to the amendment is being restrictive. I mean, the amendment in no way restricts anybody with the prosecutorial hat on from providing that information, whereas the language in there, I see it as putting a prosecutor in a situation where he's going to provide information which is going to elicit questions from the person they're talking to, which could then take them down that road of putting them into that conflict, and that's what we're trying to avoid. So,
Okay, I am going to ask for the question now. Colleagues, shall G-1 carry?
No.
Mr. Clerk, can we please, would you like a recorded vote?
Mr. Moore?
No.
Mr. Brock?
No.
Mr. Caputo?
No.
Mr. Van Popta?
No.
Mr. Fortin?
No.
Mr. Garrison?
Yes.
Mr. Maloney?
yes.
Madame Brière?
Oui.
Madame Jones? Mr. Housefather,
Yes.
Madam Dillon,
Oui.
6 yea, nay 5, carried.
G-1 is carried. I will now move to PV-5. That is deemed moved. Just to let you know, if PV-5 is adopted, PV-6 cannot be proceeded with. Miss May.
Thank you, Madam Chair. This amendment is, and I do hope that, chers collègues, everyone, I hope you'll give this one a real chance. It's it should not create any issues for anyone, regardless of whatever party you're with. This amendment is so clearly in the victim's interest and doesn't create a burden in terms of finding a victim to get their awareness of it before issuing the order. This is simply that when the order has been made, that there will be, as you can see here, that the copy of the order is provided to them. So we know from the cases in real life of people who've survived sexual assault. I mean, this is just an extraordinary reality. To survive a sexual assault, to go to the police, to successfully apprehend the perpetrator, to actually achieve a court decision that there has been a sexual assault and the perpetrator is sentenced, to ensure that the victim is aware that they've been placed under a publication ban, so they can't use their own name. They must at least be sure that the publication ban is something of which they are aware, so that they don't themselves inadvertently, after all of that, fall afoul of the law and end up being fined or sanctioned for violating a publication ban and using their own name. This amendment, I beg of you, please, to pass Parti Vert 5. It's very straightforward, and I know I'm not allowed under the terms of your order to participate in debate, so I'm just anticipating any questions. This is very straightforward, and I do hope that my colleagues will see fit to accept this amendment.
Much. Shall PV-5 carry?
Yes.
Defeated.
Is there not going to be a recorded vote?
Well, there's can only be a recorded vote if somebody asks. I don't feel it's my.
I know I'm
Madam
not
Chair, you
allowed.
can't
want-
just assume.
Well, they said no, we said yes, so I would like a recorded vote.
Oh, fair. No. If you ask, for sure. But I don't believe the chair, should be telling you to get a recorded vote, which I did before. So apologies for before. So if somebody requests it, by all means. But it's not up to the chair. So, Mr. Clerk, please.
Sure. On PV5, Mr. Moore,
Yes.
Mr. Brock,
Yes.
Mr. Caputo, Mr. Van Popta,
Yes.
Mr. Fortin,
Oui.
Mr. Garrison.
No.
Mr. Maloney,
No.
Madame Brière,
Nope.
Madame Jones, Mr. Housefather,
No.
Madame Dillon,
No.
nay 6, yea 5. Defeat.
PV-5 is defeated. PV-6 is deemed moved. Shall PV-6 carry?
No.
Thank you. PV-6 is defeated. PV-7.
Chair, I have an absolute right under the terms
Okay.
of the motion. I'm sorry, but I was trying to get my hand up. The functions are very difficult over it. I mean, I just get a hand up and get off mute to beg for something that in most committees, I have to say, it's more automatic to give me a right to speak before my amendment is defeated. Oh my, I'm so sorry, Madam Chair. I'm sorry to be emotional, but I was so shocked there.
Hey, I
if
could
we
tell you,
can-
I have my eyes glued on the screen and I did not see your hand.
because I couldn't get it up in time because of the little cursor thing wobbles all over and it doesn't always go directly to hands up. It's a little more difficult. I'm sorry, Madam Chair.
That's so we will continue with PV-7 and then here, if you want to put your hand up, please
what
do.
happened to PV6? What
I
happened to
believe
PV6?
everybody on the committee voted against it. This one did not need
I'd
a.
like to see a recorded vote.
I don't believe you have the right to request of
Well,
me,
I
the
know
chair.
the
To
people
have a
who-
recorded
my voice,
vote.
My choice who are watching this would like to know who votes against their amendments because my amendments come from their testimony.
Ms. May, every member voted against PV-6. I'm now going to move to PV-7, please. PV-7 is deemed moved. Ms. May.
Thank you. And again, the terms of this business of deeming my motions moved is all because the larger parties didn't like the rights that I do have to have put these amendments forward. If I chose to do so, if you didn't have this motion in place at your committee, I would have been able to move all of these amendments in the House in full session, and then we'd be able to have the debate. So again, the witnesses from My Voice, My Choice have made it very clear why they feel S12 needs improvements. This is one of those improvements. And I'm hoping this time, I know it doesn't seem too very likely that the amendment will be accepted, but I do urge the committee to consider this as a minor improvement to the overall scheme of S12 in the interests of the victims who otherwise find themselves under these publication bans without their knowledge. Thank you, Madam Chair.
Can I just say something, Madam Chair?
Yes, Mr. Maloney?
Just very quickly, and for Ms. May's benefit, because of her technical problems at the outset of the meeting, there was consensus around the table, Ms. May, that we all are very supportive and understand and are grateful to My Voice, My Choice. But the amendments as presented are not something that everybody can accept. So it's not in any way a reflection on them as a group or any of the individuals who we heard at this committee. I think it's important that we get that on the record and understand that before we move on.
Thank you. Where was I? Shall PV-7 carry?
Non, Madame la Présidente, je vais intervenir sur PV.
I'd like to intervene on PV7, please, Madam Chair. Your hand was not up, but go ahead. I thought I raised it. Now, yes, but not earlier. I'm sorry, Madam Chair. I see that raised hand and lower hand are on the same button here. I probably clicked the wrong one. Anyway, I'll be short here. The problem I have with PV7 is it says that the judge shall not make an order if the victim or witness indicates that they do not wish to be the subject of an order. But if there are many witnesses or victims, 3 people raped, let's say, and one says, I don't want an order, the other wants one, the judge could not render that, and that's problematic. I don't think you can adopt PV7 in its current form that requires that a single witness has the right of veto over this whole order business. And I'm really sorry, Ms. May. It's not, I have nothing against you, of course. Yes, I understand that, my friend.
Me to respond to Mr. Fontain's comment?
Yes, but yes.
Thank you. Very, very briefly. The publication order is a question of the individual's name. Each individual has their own name. So if each individual has to agree that their name be listed or not listed, that is their right. And it doesn't mean that no one can be listed. A publication ban could apply to one but not the other. But in each case, the victim or witness would have to agree that they would like to have the publication ban apply to them or not. It's a question of their personal name and whether their name is on the order. Thank you.
Thank
Madame la
you.
Présidente,
Madam Chair, may I respond to Ms. May? Yes, go ahead. I will allow you to respond to anything. Ms. May, the problem with this is what I was saying earlier. It's the wording of the prohibition. We're talking about a victim who's the subject of the order. If we said the identity, you can't prohibit publicizing the name of a person. But here we're talking about making a publication ban. And I reiterate, this cannot apply when there are many victims or many witnesses. It would have to be specific, and I agree with you that the identity of the person who doesn't want their name disclosed must be protected, whereas the identity of the person who says, I do want my name to be disclosed, has to be allowed. Okay, thank you very much, everyone.
Shall PV-7 carry?
Yes.
Recorded vote, please, Mr. Clerk.
Mr. Moore,
Yes.
Mr. Brock,
Yes.
Mr. Caputo, Mr. Van Popta,
Yes.
Mr. Fortin,
non.
Mr. Garrison, Mr. Maloney,
No.
Madame Brière,
Nope.
Madame Jones, Mr. Housefather,
No.
Madame Dillon,
No.
nays 7, yea 4 defeated.
PV-7 is defeated. I will now move to PV-8. If PV-8 is adopted, PV-9, NDP-1, G-2, G-3, and G-3.1 cannot be moved due to a line conflict.
Sorry, can you repeat that, Madam Chair?
Yes, I will. Very technical, very procedure, very legal. Here we go. We're now dealing with PV-8, and it is deemed moved. If PV-8 is adopted, then PV-9, NDP-1, G-2, G-3, and G-3.1 cannot be moved due to a line conflict, and I'm going to read where where the law is. As House of Commons Procedure and Practice 3rd edition states on page 769, amendments must be proposed following the order of the text to be amended. Once a line of a clause has been amended by the committee, it cannot be further amended by a subsequent amendment, as a given line may be amended only once. So we are going to now speak to PV-8. I note, Ms. May, you have your hand up as the mover. You can you can speak, yes. And then Monsieur
Okay.
Fortin, you can follow her.
Yeah, technically, I'm not the mover because the strangeness of this procedure to which I am enforced to comply with the procedure. Otherwise, I lose my other rights. I'm not the mover because it's deemed moved. So it's my amendment, but it's a very strange process, Madam Chair. I agree. So this amendment is attempting to deal with, again, ensuring that people who are witnesses or victims are given access to exercise their own rights under this section. This clarifies the application process to vary or revoke a publication ban. So it's under a section 486, which is the 0.5, the discretionary publication bans. So again, the two categories are in the first part of my amendment. If a witness is under the age of 18 or a victim who's subject to an order made under 486.4 asks the prosecutor to have the ban varied or revoked, the prosecutor shall, as soon as possible, rather as soon as feasible, make the application to vary or revoke that order on their behalf. And again, if the court is, if for any reason unable to act, another court can vary or revoke the publication order. Again, the point is here is to make sure that when a victim or witness who's the subject of a publication ban tries to have it removed, wants it varied or revoked, that there is a requirement that the prosecutor act on their behalf quickly, and that if there's if they're not for any reason able to get to that court, a court shall in another court hold the hearing as quickly as possible and determine whether the publication ban should remain in place, or again, this is at the request of a witness under 18 or a victim subject of the order, that they have access to justice in getting the publication ban varied or revoked. Thank you.
Monsieur Fortin?
Thank you, Madam Chair. The problem I have with PV8 is threefold. First of all, paragraph 4 is far too restrictive. It says the court must take into account the following, and it lists them. The court already takes into consideration a number of factors when there's a publication ban, when it revokes it or modifies it. The same factors should be taken into consideration. So by limiting the factors that the court can refer to, we're opening the door to decisions that won't make sense, in my opinion. The second thing, under paragraph 5, 486.5, the applicant is not required to provide notice of the application. So the problem I have here is, what are we going to do? How can we say somebody, I don't want the accused to be the subject of this. The accused has to be made aware of orders. If they contravene them, they can be accused of having contravened this publication ban. And lastly, PV8 proposes replacing some provisions of S12 when the publication ban is not applicable. And I think that we do need these provisions, these restrictions, these victim and witness restrictions. Honestly, with all due respect for Ms. May, I think PV8 would cause far more damage than it would support the victims. So thank you.
So, Ms. May, the rules are not clear, and I'm sure you probably know them more than we do here. But I'm not. I guess it's. I don't know if. I see you have your hair up again. I know. So I'm gonna have to use it discretionally, depending on the time and the number of clauses we have available. So.
If I could speak to Mr. Fortin's point.
Time you for 30 seconds. Can you do that?
Yes, in 30 seconds. Again, this partie vers 8, this amendment is only when a witness or a victim subject to an existing publication ban order seeks to have it changed. So, of course, their rights are protected because they're in the driver's seat. This amendment gives them further opportunity to vary or revoke to ask the court to vary or revoke the order. Now, of course, I hear what you're saying, Mr. Fortin, that there already are considerations the court will take into effect. But what this is looking at, the privacy interests of the victim, the freedom of expression for victim or witness.
So, Ms. May, I've been very generous, but I'm going to call the vote, and I can for PV-8.
No.
I hear all no's. I hear all no's. The PV-8 is defeated. PV-9, please.
Can I,
Yes.
Madam Chair?
No.
I've got
You have something?
Ms. May will appreciate this, and I'm not trying to preempt what she's saying. PV9 and NDP1 are very similar, but
I was going to read that, actually, may I?
what I'm about to say may actually help you or solve a problem for you anyway. Through the machinations of the procedure, which I don't always pretend to understand, PV9 ended up prior to NDP1. I agree with the spirit of both, but I have some sub-amendments to NDP1 which would not change the essence of it, but just it's some language changes that might help. I raise that now only because the changes were to the wording of NDP1, not PV9. So maybe the clerk can help steer me through that problem.
Can I suspend for a minute to seek assistance here? Do this pretty slowly. I'm going to request on the PV-9, and I have obviously on authority that I could do this. If I have unanimous consent to dispose of PV-9, then it can be disposed.
That's not allowed, Madam Chair.
Well-
That is not allowed under the motion this committee passed. It's enough to take away my rights at report stage. You can't then subsequently take away my rights at report stage and at committee summarily. I'm sorry to be, this is not something that you can do.
You can speak to it, but I do have the right to ask for unanimous consent after you speak to it. Yes.
That's right. That's all
Okay.
I have is the right to
Absolutely.
speak to it. I can't-
Go ahead.
I can't vote on it. I can't do anything else but speak to it. So thank you, Madam Chair. And by the way, if this committee would like to remove that motion altogether and allow me to present my amendments on future legislation at report stage, that's fine with me. All right. And that's what I'd like. Okay, Madam Chair, very quickly. PV9 is to ensure that people who are acting in a role of support to those who are victims are not criminalized if they're communicating information to provide assistance to the victim or the witness. I know this amendment is quite similar to NDP1. The reason it's first in the package is that we got them in first. But I do think, although NDP1 is a different attempt to do the same thing, I think the language here, with all respect to the other amendment, that this language is stronger. The effort here is to ensure that when it's not the purpose of the disclosure to make the information known to the public, but in order to provide support to the victim or the witness by, and this is the category of people we're looking at, legal professionals, counselors, medical professionals, or people in a relationship of trust with the witness or victim, are not to be criminalized when acting in the interest of that witness or victim. Thank you, Madam Chair.
Okay. Can I call for the vote? Oh, Mr. Garrison?
Thank you, Madam Chair. I'll try and restrain my comments to this. I think that, of course, all people around the table have heard testimony from victims. Some of us have dealt with them for a number of years before this came here. And so there are obviously differences of opinion about what we can accomplish in this bill given the timeframes that we're dealing with and the Senate. That said, PV9, NDP1, and the additional motion brought forward by the government are all very similar and try to accomplish the same thing. I've seen the government's motion. I believe it more simply accomplishes the same goal that's in PV9 and NDP1. I would ask the committee to defeat both and deal with the government's substitute motion on this section.
Monsieur Fortin?
Mr. Fortin? No? Yes, thank you, Madam Chair. I'm looking at NDP 1 and PV 9. I agree with both, really, except for one thing. I would propose that we amend PV 9 or NDP 1, as the case may be, because paragraph C that is being added here says, provide support to the victim or witness through, let me start over. Information is made for the purpose of providing support by legal professionals, counselors, medical professionals, or persons, etc. It's the other way around. What we want to protect here is the right of the victim to talk to their lawyer, their psychologist, their counselor. What the text is telling us, and the English is the same, by legal professionals, and to legal professionals. We want the victim to be able to talk to their lawyer, to their doctor, to their psychologist, without countering the publication ban. So with all due respect, Madam Chair, I propose that PV9 be changed or amended by saying to instead of by, and I'll let more competent people deal with the English, but at least in the French, I'd replace par by a. Thank you.
We have a sub-amendment on the floor. Mr. Fortin just...
Monsieur Fortin?
Mr. Fortin,
Oui.
did you submit your some amendment in writing? No. It doesn't matter to me, Madam Chair. I'm saying we have a wording problem. If we want to adopt it this way, go ahead. But at one point, you have to be consistent. I noticed it just earlier. I'll submit this to you, but I'll let you decide on the relevance or pertinence of amending it or not. This is not an amendment of substance here. It's just a way of wording it. There's a problem here. It's not like a major amendment on the substance of the thing.
Madame Chair,
Oui, Madame Brière.
je pense que notre...
I think that our amendment solves the problem raised by Mr. Fortin. Very well.
Quel amendement?
Which amendment?
G3? G3.
G3. No? No.
Document that the clerk has.
It has been sent to everyone.
It has been sent to everybody?
3.1?
I believe,
Beginning of the meeting.
at the beginning. So everybody should have a copy of it from the beginning of the meeting. That there was a sub-amendment provided to the clerk that was distributed to the members immediately prior to or at the outset of the meeting.
Je ne l'ai pas reçu, je crois, monsieur.
I don't have it.
Your email, Mr. Fortin.
Don't see it. Sorry.
The clerk is telling me he has sent it to everyone. Which
Mr.
one is it?
Housefather has his hand up too.
Mr. Housefather?
Juste pour clarifier, parce que je crois que nous sommes un peu...
I think we're a bit lost here. Mr. Fortin moved a sub-amendment. It's okay. I agree with him. I don't think we should take the time to work on that because it will be lost. The government submitted a new amendment covering the same aspect of as NDP 1. And the problem Mr. Fortin has raised is solved by this new amendment. Does that explain? Yes, I didn't see the amendment, but if it's solved, okay. It's not a question of substance. I agree with all that. I just want to make sure that it's worded properly.
Me then as the chair to ask for if PV-9 shall carry.
Yes.
I hear no's and I hear yeses and I hear more no's.
No.
Did he say? Meaning you want to, okay, yes, Mr. Chair.
On PV9, Mr. Moore,
Yes.
Mr. Brock,
Yes.
Mr. Caputo, Mr. Van Popta,
Yes.
Mr. Fortin,
No.
Mr. Garrison,
No.
Mr. Maloney,
No.
Madame Brière,
No.
Madame Jones, Mr. Housewater,
No.
Madame Dillon,
No.
Nay 7, U4, defeated.
PV-9, this defeated. I have a new nouveau, NDP-1. Does the member want to move it? No. Okay. That one is gone. I have a G-2.
No, well, there's the new the new amendment that's being proposed in lieu of NDP 1, which is
No, but it has to go in order.
the time to do it.
That's not the
Okay,
time yet,
okay.
no, just. So, G-2.
Moved.
Moved by Mr. Maloney. Shall G-2 carry?
Yes.
Yes? Carried.
No. No, no, no.
No, no, no. I'd like to speak to G2, Madam Chair. Well, please raise your hand, Mr. Fortin. Well, things are going fast here. I'm trying to follow. I'm looking at the motions. Anyway, look, I don't want to waste any time here, but G2, it's the same problem in G2. It happens in G4 too. G2 and G4, in all due respect, my opinion, have the same problem. I know there's this English version here, but whether it's French or English, this will help the courts interpret the law. And when you say who is the subject of the order, it doesn't take into account that it's not the accused, or rather the victim, who is the subject of an order. It's their identity that is targeted by a publication ban. So the wording we have here, who is the subject of the order, is as if the order is only applicable to the victim. The victim is ordered not to publish X, Y, or Z, according to what's ordered, but it doesn't concern the public, the journalists, the clerks, the other lawyers. That's not what we want. The publication ban is for everybody. Everyone is the subject of an order, but it protects rather than the subject. It's the beneficiary, if you wish. The victim is the beneficiary of the order. But to be clearer, rather than say who is the subject, we should say whose identity is the subject of the order. Thank you, Madam Chair.
Ça pourrait être un sous-amendement.
It could be a sub-amendment if the government agrees.
So G2, shall G2 carry?
Yes.
Yes.
No. No.
On division?
Je peux pas voter.
I can't say yes. It's the wording is, well, anyway.
Thank you. G3. Can I ask, Mr. Maloney is moving G3. Shall G-3 carry? Carried. Thank you very much. We have a new G-3-1, but we're going to ask that it be read because it was submitted new.
Sorry, this is different than the one that was distributed by email?
No, but there's a bit of confusion as to how they distributed it. So if you don't mind, is it a long one?
Moi, Madame la Présidente, je n'ai
Madam Chair, I did not received this amendment. I'm looking for it, but I don't see it anywhere. If it was sent, I don't know where it was sent or how. The clerk wants to say something. He wants to tell you when he sent it. Go ahead. Mr. Fortin, if you look at your email at 16:16, there were 4 amendments sent. You don't have G 3.1 as such. The mover would have to read the series of numbers at the top left. Okay, well, given the number of emails we get, if they're not identified properly and the speed with which we work, it's very hard. I don't want to delay the committee unduly, but I do want to do this job properly.
Mr. Maloney, once you're ready.
All right, I'm advised by the clerk that the number on the document may help Mr. Fortin at 002-003-13A. Okay, so
I
the,
have no, oh, yeah, 13. Okay.
okay,
Je l'ouvre.
I'm opening it.
16A is the French version? Okay, all right, thank you. Okay, I'm going to read the English version, which everybody will be
Non,
grateful
mais
for.
Madame la Présidente,
Madam Chair, this is serious here, what I'm saying. I don't think anyone thinks that our work is pointless. We're in a hurry, yes, but we have to do it properly. I think I'm correct in asking that documents be identified correctly, and I don't think there's anything funny about that. If I don't understand what we're talking about, I can't work intelligently, and my job as an MP is to work smartly, out of respect for the witnesses we heard and for the entire population.
No, absolutely.
Absolutely, yes. Mr. Maloney, please go ahead. Did you find the document, Mr. Fortin? Yes, I have it. I have it in front of me. Okay, very good. Mr. Maloney, could you read it in English?
That Bill S12 in Clause 2 be amended by replacing line 13 on page 3 with the following. Make the information known to the public, including when the disclosure is made to a legal professional, a healthcare professional, or a person in a relationship of trust with the victim or witness.
je demanderai 2 minutes, Madame la Présidente.
I'd ask for 2 minutes, Madam Chair. I'd like to understand the text of this.
Je suis d'accord et effectivement.
I agree. And that does solve the problem we had earlier. It's communication to a professional, and I'm satisfied with that. Thank you, Mr. Maloney. Thank you, Mr. Martin.
All the, well, I guess you should be saying call the question, but here we go. Shall G-3.1 carry? Yes. Okay, I hear a yes from everybody. It is carried. So now, shall clause 2 as amended carry?
Yes.
Thank you. It's carried. We move to clause 3. We have G-4. Mr. Maloney is moving it. Thank you very much. Shall G-4 carry?
Yes.
Yes.
Thank you.
Je voudrais,
With your permission, Madam Chair, I'd like to reiterate my comments from earlier. We're still saying that the victim is the subject of the order, whereas it's not the victim, but their identity. There's an important distinction here. There are lawyers around the table. I can't believe that nobody's noted this. This is serious. But anyway, I'm commenting on this. Do what you wish.
I don't remember if we moved it, but thank you, Monsieur Fortin. I get, shall G-4 carry?
Yes.
We did move it. Thank you.
On division.
On division, merci. G-5, moved by Mr. Maloney. Shall G-5 carry?
Yes.
Thank you. It is carried. We have one that was distributed. Monsieur Fortin, c'est G-5.1. Avez-vous trouvé
OK,
cette...
et quel-
I don't have time. I'm doing the same work you are doing, and I can't do three things at once. Can you tell me what number this is? 003 37A FR. Thank you, Madam Chair.
Okay, Madam Chair?
Yes, Monsieur Maloney.
Okay, so the new language would be that Bill S12 in Clause 3 be amended by replacing line 33 on page 3 with the following: to the public, including when the disclosure is made to a legal professional, a healthcare professional, or a person in a relationship of trust with the victim or witness or justice system participant.
Moi, ça me convient, Madame la Présidente.
That's fine with me for the same reasons as earlier. Thank you, Mr. Maloney.
I will, shall G-5.1 carry?
Yes.
We still have G6.
G6, Mr. Maloney, thank you. Shall G-6 carry?
Yes.
I hear no's and I hear yeses. Mr. Clerk, can we have a recorded vote, please?
Madam Chair, this amendment deletes lines that state the prosecutor's role in informing a victim or witness about the effects and circumstances of a publication ban. That is the exact opposite of what was asked for by witnesses that appeared. They wanted an increased role in and increased in information that was provided. So Conservatives will be voting against this amendment.
Thank you. Mr.
Et c'est-
Oui, Monsieur Fortin.
Yes, Mr. Fortin. I wanted to say that I completely agree with what Mr. Moore said. That's the discussion we had earlier. I don't want to repeat it in its entirety, but victims are asking us to inform them more, and we're telling them we're going to inform you as little as possible. There's an order that was made. It concerns you. We're not going to tell you what it is, but I don't think it's very respectful to witnesses. Thank you.
Shall G-6 carry? I think I heard yeses and no.
Yes.
Mr. Clerk, can we have a recorded vote?
On G6, Mr. Moore,
No.
Mr. Brock,
No.
Mr. Caputo, Mr. Van Popta,
No.
Mr. Fortin,
Non.
Mr. Garrison,
Yes.
Mr. Maloney,
Yes.
Madame Brière,
Oui.
Madame Jones, Mr. Housefather,
Yes.
Madame Dillon,
Yes.
E6, name 5, carry.
G6 is carried. Shall Clause 3 as amended carry?
Yes.
Carried. Clause 4. G-7. Mr. Maloney, thank you. Shall G-7 carry?
Non.
So I'm not sure what I'm hearing. Can we have a
No.
recorded?
No.
Yes? Mr. Moore, did you want to?
No.
No?
Madam Chair, for these reasons, and I don't understand now having S12, now we see the government making amendments, but what this amendment would do is to further consider more privacy interest of the accused when contemplating the privacy interest of a person subject to a publication ban. And that is not what we heard at committee. That's the exact opposite of what we've heard at committee. We have victims that have been through the worst possible situation in their life, and they feel re-victimized by the justice system. So I don't understand where this amendment is coming from when it's the government's amending its own legislation, but Conservatives will be voting against this amendment.
Mr. Brock?
Thank you, Madam Chair. Wholeheartedly endorse my colleague's comments. I wish to put on the record as well that the only way that I see this actually having any impact, and this is currently what happens routinely before the court, is the privacy interest of the accused generally will occur in terms of publication bans where to identify the accused might compromise the integrity and privacy interests of the victim. In other words, a victim who's the has been sexualized or sexually abused by the accused in a familial relationship. It's automatic that in those situations that the privacy interests of the accused have application, and in those situations, their name plus the name of the victim would be subject to a publication ban. This particular amendment does not speak to that, and I think for broader reasons, it should be defeated.
Mr. Garrison?
Thank you very much, Madam Chair. I don't read this amendment the same way. What I read this amendment doing is precisely what the Conservatives are talking about. It removes any ability of the accused by not including them in this clause to make use of privacy rights in a case like this. So I think it actually accomplishes exactly the opposite of what the Conservative members are arguing. I think, and just to be, I guess I'll be fair to the government, this was a government bill which was amended in the Senate, so this has gotten quite complex because it's already been amended in the other house and comes back to us with those amendments in place. So this, I think, clarifies the original intention, and I think it does what those who are survivors wanted, is make sure that the accused can't make use of privacy rights in these proceedings.
Monsieur Fortin?
Merci, Madame la Présidente.
Thank you, Madam Chair. I, too, am against this. The clause we're working on says that the court that made the order, or another court, is obliged to amend or revoke it when that's requested if it feels, unless it feels that it affects the privacy rights of any person other than the accused. Now it says will remove other than the accused. So what this means is that the court will make the order and will have to take into account the privacy rights of the accused. So if the victim says, well, we have to amend this order for this or that reason, if the court feels that this would harm the accused, it cannot do that. So I agree with what Mr. Garrison said. This is quite a complex text. We can't figure this out in 2 minutes, but when you read it carefully, you see that G7's effect would be to protect the accused to the detriment of the victims. We're giving the accused a right of regard over any eventual amendment of a publication ban. So once again, with all due respect, I think this is counterproductive, Madam Chair. Thank you for your intervention. Now.
Sorry. Shall G-7 carry? No. I hear no's and I hear yeses. Mr. Clerk, can I ask you to take the vote?
On G7, Mr. Moore,
No.
Mr. Brock,
No.
Mr. Caputo,
No.
Mr. Van Porta,
No.
Mr. Fortin,
No.
Mr. Garrison,
Yes.
Mr. Maloney,
Yes.
Madame Brière,
Oui.
Madame Jones,
Yes.
Mr. Housefather,
Yes.
Madame Dillon,
Oui.
E6, E5, carry.
Je peux pas croire.
So G7 carried. Shall clause 4 as
G7
amended?
is defeat? Sorry, j'ai pas compris, Madame la Présidente.
I'm sorry, I misunderstood. You said G7 is defeated? No.
Posé, c'est adopté. Oui, oui, oui.
Ah, OK.
Shall clause 4 as amended carry?
Yes.
Okay, carried. Thank you. So we have clause 5 and clause 6. There's no amendment submitted to both of those clauses. Can I get unanimous consent to group them together for the vote and ask if clauses 5 and 6 carry? Okay, Both of those are carried.
You asked for unanimous consent to group them,
Oh.
just to be clear. So now we would consider them.
So now let's consider them, okay. So shall clause 5 and clause 6 carry? I
Oui.
thought I asked that already, though. I did. You want to stay here tonight, do you? I'm okay. Clause 7. All right, here we have CPC-4. Can somebody please move that?
Thank you, Madam Chair. I'm going to move this amendment. This goes to the heart of our system, our justice system, and how it treats the victims of sexual offenses and how it protects our communities. So the sex offender registry, prior to the Supreme Court decision, required the automatic registration of individuals that had committed certain sexual offenses. In a narrow, there's 9 members of the Supreme Court. It was a 5-4 decision with a very strong dissent. Found that this automatic listing violated the Constitution. They gave the government a year to respond. Now we're up against that deadline. That deadline is at the end of this month. And what's come back with S12, in my opinion, does not go far enough. For example, for an automatic listing now on the sex offender registry, if you read the dissent in the Supreme Court decision, they said judges were not properly exercising their discretion by excluding individuals. The federal registry only had a 50% inclusion rate, where that was the same as in Ontario, where when it was left to the discretion, there was only about a 50% inclusion, when the Supreme Court found that an offender on the registry is 8 times more likely to offend than the general public. So there is a pressing reason to have sex offenders on the sex offender registry. That has been established. What this bill S12 does is, in order for someone to be automatically listed under section 490.012, the designated offense has to be prosecuted by way of indictment, number 1. The sentence for the designated offense is a term of imprisonment of 2 years or more, number 2. And this is key, that "and" word, the victim of the designated offense is under the age of 18 years. So that is how an automatic listing on the registry would take place. This is far too narrow. That is why I've introduced our amendment, which would delete paragraph A and B on page 11 of the bill, so that all designated offenses, regardless if by proceeding by way of summary or indictment, if they are committed against a child victim, someone under the age of 18, it requires mandatory registration. We heard testimony that suggests that that would meet the decision that has been laid out by the Supreme Court, and I would urge members to consider broadening this piece of legislation so that we can protect child victims of sexual offenses, protect our communities against sex offenders, and require the mandatory listing in the sex offender registry of individuals who commit an offense against a victim who is under 18 years of age. So that is what this amendment does.
Before anyone else speaks, okay? 2 things. One, we will go till 6:30 if we don't finish tonight. Well, we have the room till 6:30 and we're going to finish. So we might be able to finish in 10 minutes. That's the other thing is procedurally, I need to read. If CPC-4 is adopted, CPC-5 and CPC-6 cannot be moved due to a line conflict. And Mr. Caputa.
Yes, point of order, Madam Chair. I believe that unanimous consent is required to push the meeting beyond its time. I would love to stay here. Both Mr. Brock and I do have flights. It's rather unfortunate that we are here. This has been said so many times. Decision came down October 29th of 2022, and here we are rushing. This will, we'll have to pick it up at some other time,
I'll get advice from the table on that and get back to you. I won't, it's not up to me. I won't be, I'll get advice and see what. I do know that we received notice that we have it till 6:30, and let me get advice. But let's continue with the, we may not need it.
Yes, and I'll just be clear, I would
CPC-4.
like to stay, but I cannot.
Anyone wishes to speak on that one? Oh,
Oui.
Mr. Brock,
On what? on the-
CPC-4.
Yes, I do. I just wanted to add something for discussion. Madam Chair, thank you. So I believe we heard some evidence, and perhaps Matthew Taylor or Ms. Wells can weigh in on this. But in practical terms, the vast number of convictions of sex offenders involving children under the age of 18 are preceded by summary conviction. And as the criminal code is set out, if proceeding by summary conviction, the maximum penalty is 18 months. So in my view, as a former prosecutor, whether it's a history of sexual offending or a one-off involving a child, whether a judge with or without expert evidence from defense or for the Crown, in my respectful view, a low risk is still a risk. And that's the same language that came from the dissenting opinion of the Supreme Court of Canada. And let's take a look at the identity of the justices who were part of that dissenting opinion. We've got the Chief Justice of the Supreme Court of Canada. We have Justice Moldaver, who's now retired, who was known, and certainly Matthew Taylor and Joanna Wells can confirm this, because I know my colleague, Mr. Caputo, will certainly can confirm this. He was considered the expert. He was the dean insofar as criminal jurisprudence was concerned. So I take that language, I agree it's dissenting and it's not binding, but I take that language very, very seriously. So this particular bill broadens that net to ensure that all of those offenders, whether preceded by indictment as contemplated by S12 or by summary conviction, will be captured by the Registration Act. Am I correct, Mr. Taylor?
I thank you for the question. I don't have the specifics in terms of the charging breakdown for summary conviction versus indictment. I mean, we've talked previously, Ms. Wells talked previously as to why the criteria have been set the way they've been set. Certainly, in a case where a Crown believes that there is a risk and they want the mandatory registration, they have the option to proceed indictably. But importantly, and Ms. Wells can supplement, even in cases where they proceed summarily, they will be presumptively registered. So they are on the list unless the offender can demonstrate why they shouldn't be on the list.
Yeah, I don't know if you got it.
Any other speakers on this one? I'm going to ask for the vote. Sorry, I'm going to ask. Shall CPC-4 carry?
Yes.
Yes.
Mr. Clerk,
No.
can you take the vote? Or is it on division? You want to vote? Definitely, for sure. Go ahead.
Sure. On CPC4, Mr. Moore,
Yes.
Mr. Brock,
Yes.
Mr. Caputo,
Yes.
Mr. Van Popta,
Yes.
Mr. Fortin,
No.
Mr. Garrison,
No.
Mr. Maloney,
No.
Madame Brière,
Nope.
Madame Jones, Mr. Housefather,
No.
Madame Dillon,
No.
Nay 7, Yea 4, defeated.
Thank you very much. CPC-4 is defeated. We now have CPC-5. Is there a mover for this one? Mr. Caputo?
Yes.
And before you do, if CPC-5 is adopted, CPC-6 cannot be moved due to a line conflict. So,
Madam Chair. Okay. I'm just going to echo the sentiments again of Mr. Brock. I think if we were to go and look, and candidly, may not surprise people around the table, but I'm a bit of a nerd. I still read a lot of case law because I find it interesting, and I also want to know what we're dealing with, and especially in areas like this. So for BC Court of Appeal decisions, BC Supreme Court decisions, for instance, I frequently read the decisions, and I can tell you it is not uncommon. It's actually very common to have offenses under, say, Section 163.1 sub 4, which is the possession of child sexual abuse and exploitation materials, to be under 2 years, or to be not preceded by indictment, and that sometimes is done by consent. So when we look at this and we consider whether or not that person should be registered, at the end of the day, the greatest somebody has not only victimized that child has been re-victimized in the case of possession of those materials time after time after time, and research tells us that the person who has done so is at an elevated risk, a substantial risk, not even just a 50% plus one, a substantial and elevated risk to offend. Somebody who is seeking out that material is seeking it out for a reason. And there, in my view, is often an escalation of what somebody does. Usually offending behavior does not decrease. It will increase. So I don't know how we as a committee and as parliamentarians wouldn't want to recommend the inclusion of such people, and rather than restricting it, because so few people will be caught by this. And I'm mindful of the presumption, but this isn't a matter of presumption. This is a matter of we as Parliament should be speaking and saying those who are at a heightened risk or even a risk to offend against children will not be presumptive. They will be included on the registry.
thank you. I did that already. Shall CPC-5 carry?
Yes.
Okay, recorded division.
Thank you. On CPC 5, Mr. Moore,
Yes.
Mr. Brock,
Absolutely.
Mr. Caputo,
Yes.
Mr. Porta,
Yes.
Mr. Fortin,
Non.
Mr. Garrison. No. Mr. Maloney,
No.
Madame Brière,
No.
Madame Jones. Mr. Housewater,
No.
Madame Dillon,
No.
I still have this one, don't
May 7th, you 4.
I? We're dealing with now. I dealt with that one, did I not?
We just finished CPC 5, so now we're on CPC 6.
Oh my God, I'm with. So CPC- what did you give me?
May 7th, you 4.
Which one was it?
CPC 5.
CPC-5 is defeated. I'm going ahead here too fast, but we are continuing, folks, just so that you know. CPC-6,
Continuing, Madam Chair, if I can get clarification, continuing beyond 5:30?
yes. So I'm going to continue now with CPC-6.
I can speak.
Mr. Brock?
Yeah. CP6 is largely CP5
Yes.
language. The rationale behind it from both my interventions and Mr. Caputo's interventions still apply. The only difference between 6 and 5 is without the addition of offense involving a person with a disability.
I will now ask if CPC-6 carries.
Absolutely.
Yes.
Okay, so defeated on division?
Yes.
Thank you. CPC-7? Is there is
J'ai
some,
pas de CPC-7.
I don't have CPC-7. I suppose it's part of these amendments that were sent later. Could the clerk please enlighten me? Well, it was sent at the beginning of the meeting, Mr. Fortin, a single amendment. CPC 7. I'm sorry, I have it.
Il est envoyé à 16h13, c'est ça?
Consensus is trying.
Mr. Van Popta, do you move?
CPC 7.
Thank you very much. Sorry?
I'll speak to it.
Oh, yes, please.
Yeah, just take me a minute. I was inspired to put forward this amendment by the testimony that we heard from Dr. Robick, Federal Ombudsman for Victims of Crime, and Professor Benedette, who said that that the bill would be improved drastically by, in addition to the factors that a judge should consider, that there should also be a list of the factors that a judge should not consider. And they referred us to a paper written by Professor Benedette on exactly that topic, where she said that, and I read the paper, she studied 155 cases where a judge gave an exemption from an order, and she analyzed them, and she found that there's, in her opinion, flawed reasoning. And I'm just going to read one section. Taken as a whole, these decisions provide some interesting insight into how judges understand the seriousness of various kinds of sexual assaults and the purpose of the registry. More specifically, they show the way in which rape myths can creep back into judicial decision-making even after conviction and sentencing. And then she concludes with, Parliament should respond by setting out a list of irrelevant factors akin to those found in the Criminal Code provisions on the production of third-party records in sexual offense prosecutions. And Dr. Robick and Professor Benedict both spoke to that at Tuesday's meeting, and motion CPC 7 captures that. Thank you.
Mr. Maloney?
I remember the evidence because I think I was the one who.
C'est moi qui avais posé la question.
In my experience, the more you include, the more you exclude, because lawyers, crafty lawyers like those on the other side of the table, will see a list and then argue that it's exhaustive. And we've all encountered that many times, and it's a pitfall I don't think we want to fall into necessarily here.
Okay. I am going to ask, shall CPC-7 carry? No? Okay. I'm going to say it's defeated on division. Thank you very much. Shall Clause 7 carry?
Yes.
Carried. All right. Please listen carefully. There are no amendments submitted to clauses 8 to 48. Do we have unanimous consent to group them for the vote? And no.
Desperately want to get out of here.
So So, can I ask if clauses 8 to 32 carry?
If they're
Wait.
easy to group them, and then
Okay, do you consent to group clauses 8 to 32?
Yes.
Shall clauses 8 to 32 carry?
Yes.
Carried.
Oui.
I don't have. I'm going to call for clause 32.1. Shall clause 32.1 carry? No? Okay, clause 32.1 is defeated. Clauses says 33 to clause 48 have no amendments. Can I ask to group them together?
Yes.
Can I? Well, the answer is yes. Thank you.
Oui.
Can I now ask, and I'm going to ask, shall clauses 33 to 48 carry?
Yes.
Oui.
So they're all carried. There's a new clause 48.1, G8, moved by Mr. Maloney. Shall G-8 carry?
Oui.
G-8 is carried. Shall clause 49 carry?
Oui.
Clause 49 is carried. Shall the title carry?
Oui.
The title is carried. Shall the bill as amended carry? The bill
On
is,
division.
okay. The bill as amended is carried on division. Shall the chair report the bill as amended to the House?
Oui.
The chair will report the bill as amended to the House. That concludes the clause by clause. Thank you, everyone. Have a wonderful evening. Very appreciate the wonderful way that we've done the clause by clause. So thank you so much. Bye-bye.
Bonne fin de journée.